And welcome back. It's Monday and time for Law 101. I'm Rob Levine from Rob Levine and Associates. So we started talking about the definition of negligence 2 weeks ago. We've covered duty. Last week we covered breach. And today we're going to talk about causation. So what does causation mean and how does that apply to proving that the defendant is responsible for your injuries? So there's two parts to causation. One is liability, showing that the action that caused your injuries the defendant is responsible for, and two is your actual injury, that they're responsible for that as well. So let's talk about the actual injury itself, because that's the simplest. That comes from your doctor. So your doctor has to be able to say that to a reasonable degree of medical certainty that your injury was caused by the actual accident itself, that there's a direct link between what the defendant did and what happened to you. As far as liability is concerned, we look at a different standard first. So the most general standard, the catch-all standard, we could say, is the but-for test. But for the conduct of the defendant, would your injury have occurred? So in a motor vehicle accident, clearly, but for the defendant taking a left-hand turn in front of me, I would not have struck his vehicle. But for the banister being loose in the hallway, I would not have fallen down the stairs when the banister came off the wall. So but for generally covers everything. So it's a little too broad. So in addition to but for, we have to say, was it reasonably foreseeable? So what does that mean? So we'll use an example. So I'm driving along and you rear end me. Well, but for you rear-ending me, clearly the accident occurred. An ambulance comes and picks me up. The ambulance on the way to the hospital, traveling with lights and sirens, goes through a red light and collides with an 18-wheeler. Well, but for you rear-ending me, I clearly would not have been in an ambulance and that wouldn't have happened. Is it reasonably foreseeable that on the way to the hospital, I could get into another accident while being transported by a rescue? Absolutely. It happens frequently, and it definitely is reasonably foreseeable. So we could still go back and blame the original defendant for my injuries that are caused by the first accident when he rear-ended me and the second accident when the 18-wheeler came through. At the hospital, it's determined that I need surgery. They take me to the operating room. The doctor perform surgery on the wrong side of my body, so he makes a mistake. In addition to that, while staying at the hospital, I contract MRSA, an infection that's in hospitals. So, but for the original accident that brought me to the hospital, none of this would have happened. However, is it reasonably foreseeable? So is it reasonably foreseeable that a doctor is going to perform a wrong side surgery? No, that's probably not reasonably foreseeable. It doesn't happen often, and we could not blame the original defendant. However, is it reasonably foreseeable that I contract MRSA? The answer, in my opinion, would be yes. MRSA is recognized in many hospitals. It's an infection problem, a disease control problem, and a percentage of patients that visit the hospital contract it. So we could originally go back to the first defendant and say, you're responsible for not only rear-ending me, not only the injuries that occurred in the ambulance accident, as well as my contracting MRSA. So those are the pieces that make up causation. Thanks for joining us here today for Law 101. I know it's a lot of information, but it's information you need to know. So if you like what you hear, like us, share us, and follow us on Facebook. Thanks, and have a great day. We'll see you next Monday.